A three-judge bench of the Supreme Court has begun hearing the mercy petition filed by 1993 blast death row convict Yakub Memon. The investigating officer of the case has also reached the Supreme Court. This after a two-judge bench was split on his plea, seeking a stay on the execution. Now the new bench will decide whether to stay the death warrant issued by the Tada court or not. It will also decide whether Yakub's curative petition should be heard afresh. Justice Anil Dave and Justice Kurian Joseph differed sharply on Yakub's mercy plea. Justice Dave had dismissed his plea and Justice Kurian differed and favoured a stay, saying that Yakub's petition must be heard afresh. Earlier, Yakub Memon had challenged the death warrant, saying that it was issued before he could exhaust all legal options. All right, we're getting some more bits of information in this. Is that Yakub Memon has filed a fresh mercy plea with the President. Remember, his mercy plea has once been rejected by the President already. This is a fresh mercy plea that Yakub Memon has now placed with the President. Sahil Joshi, Bureau Chief of Mumbai, is now joining us with more details. Sahil, you know, he had already exhausted the option of going to the President. What is the reasoning behind going to the President again with a fresh mercy plea?
See, earlier what Yakub and Yakub's lawyers were claiming, that earlier the mercy petition which was sent to the President was sent by his brother Suleiman Memon, who was acquitted in 1993 blast case. Now the fresh mercy petition has been filed by Yakub Memon in his own handwriting, and he has handed it over to the jail authorities, and the jail authorities with due process will send it to the President. In this mercy petition, he has claimed that his mental...
All right, we seem to have lost our contact there with Sahil Joshi. We'll of course go back to him in just a bit. Joining us now is also Mustafa Sheikh from outside Yakub Memon's family's residence. Mustafa, there is a fresh mercy petition that Yakub Memon has apparently written in his own handwriting and sent across to the President now. Are you hearing anything from the family presently?
See, the family, they are not coming on record to say anything, but this was their plan. Like basically, their plan was that if something doesn't work out in Supreme Court and the governor rejects mercy petitions of Yakub Memon, Yakub Memon was going to send a handwritten fresh mercy petition to the President. He has done this now because there is no time left, just a day before the death warrant execution date is lying, and whatever, they don't know whether the Supreme Court judgment will be in their favor or not. So basically, it's a safe side thing that they're using now all their options to delay this death warrant and get away with it anyhow. So the last option available with them was the President's mercy petition. They have done that. The family is saying that they have full faith in judiciary, and they want that that punishment should be delayed and there should be a fresh hearing on it.
All right, Sahil Joshi is back with us. Sahil, you were taking us through the reason behind why this fresh mercy petition has been sent to the President.
What Yakub Memon's lawyer are claiming is that the earlier mercy petition which was sent to the President and which has been rejected by the President was sent by his brother Suleiman Memon on behalf of Yakub Memon. Now Yakub Memon himself has sent this particular mercy petition, and they have been thinking about sending this mercy petition since last week, since the time the curative petition has been rejected by the court, by the bench of the Supreme Court. After that, they had sent a mercy petition to the governor, which is still pending, but they have realized that finally this mercy petition will have to be sent to the President, and that is why in a written application in his own handwriting, Yakub Memon has sent this particular mercy petition to the President. Now what he is claiming in that mercy petition is that his mental condition, because he has been in the jail for last 22 years, is not stable. Planters in 1993 blast case has already been given a life sentence. He has already served 22 years in the jail, and there is no point now that he should be hanged in 1993 blast case. These are the pointers, around 6 points he has made mercy plea to the President. He has handed this over to the jail authorities just a while back. Jail authorities in a due process are likely to send it to the But now the whole eyes are on what happens in the Supreme Court, because the bench is going to decide Yakub's fate at this point of time. So there are a lot of things happening in this. Maharashtra Chief Minister is also going to make a statement in the Assembly, but he's also waiting for what is happening in the Supreme Court at this point of time.
All right. Senior lawyer Yakub Memon is also now joining us for a perspective on this fresh details that have come in. Mr. Memon, Yakub Memon has put in a fresh application with the President, a mercy plea written in his own handwriting, and which points out that his mental condition is not stable and therefore he should be pardoned. Now, does it really matter who the mercy petition goes through from? Because the last time it was sent by his brother is what we understand.
Well, you see, one thing must be understood, and that is that for any proceedings in law, in the eyes of the legal system under the Constitution of India, has to assume finality at some point of time. Nothing can perpetuate or can go on indefinitely, round and round and round, and that would lose the meaning or the purpose of such provision. Now, but you see, one corollary which I would apply in the matters of death. You see, death is the extreme punishment that is, of course, known because it is absolute opposite of right life. Now, death is something once awarded, executed, then it cannot be retrieved, and therefore, if anything happens subsequent thereto to find that there was some human error or there was some non-appreciation of the fact, then we cannot forgive ourselves and go back. But as far as mercy petition before President is concerned, between the last mercy petition rejected and the fresh mercy petition filed, if there are any events which are included in this mercy petition, then probably it would lie.
Okay. Mr. Yakub Memon, many thanks for joining us with your understanding on that subject. Let me go across to Kapil Sankla, Supreme Court advocate, who's joining us here in the studio. Also, our consulting editor Rajdeep Sardesai with us. Sir, first to you. Can you help us understand? I mean, Yakub Memon made a point there that, the intervening period, if there are changes and then a fresh mercy petition is put up, only then will, it can be reconsidered. But in this particular case, what Sahil was also pointing out is that this has been made by himself, this mercy petition. The last one was done by his brother. Does that factor really matter? Because aren't cases decided on facts?
You're absolutely right. You see, there are two parts of the argument. One, if he is mentally unstable, he could not send a mercy petition in his own name. And secondly, the law of the land is very fair. In a criminal matter, if a person is incarcerated, he can file a case through a perukar, which is a blood relative or somebody else who takes care of his matter. That having been done, his brother having moved a curative petition, this curative petition would not, or the clemency would not lie. So that is the second part of the argument. Though the Supreme Court, under its inherent powers, under Article 142 of the Constitution of India, can take into consideration any subsequent fact. But as I was saying, that the larger bench constituted would now be looking into whether the first curative petition was right or wrong. And only then would the subsequent facts be taken into consideration.
Okay. Rajdeep, do you think these are desperate measures being used now by the family and by Yakub himself because they are simply running out of time?
Look, at the end of the day, you're right. He has 24 hours really between life and death. However, it is a matter of life and death. So, one can understand the desperation. At the end of the day, what's happening in the Supreme Court today is critical. You've got a 3-judge bench that is looking at the validity of the curative petition. There is another petition that Yakub Memon has also filed before it, challenging the validity of the death warrant itself that was issued. Both these petitions are before the 3-judge bench. They could be dismissed outright today, or the judge could decide, the judges in their wisdom could decide they need further hearing on it. They could thereby give a stay on the execution. So I think what happens in the Supreme Court today is critical. The mercy petition before the president, there's a mercy petition also before the Maharashtra governor, I don't think will determine Yakub's fate as much as what the Supreme Court decides today. Should the Supreme Court decide that we need more time to hear the petitions that Yakub has placed, both in terms of the curative petition and the death warrant which has been issued, then you have a possibility that the court may well put a stay on the execution which was scheduled for 30th and say we need more time. And that time then could be bought by Yakub Memon to put additional facts, substantive facts, which are not before the Supreme Court. Supreme Court is only ruling on procedure today.
Yes.
Correct me if I'm wrong. Purely on procedure about whether the curative petition and the review petition should have been held, should have been decided by the same judges or not, and whether the curative petition, when it was dismissed, the death warrant was issued even before the curative petition was dismissed. Those are procedural matters. The substantive issues, whether it is the letter which has emerged of a former raw official suggesting that there was some kind of a plea bargain which was entered into, reports which have suggested that Yakub Memon did go out of his way to help the authorities, those material facts could now be placed possibly before the president or the governor, but not at the moment. I think at the moment it's about procedural issues. If the curative petition is dismissed, then I don't see what will stand in the way between Yakub Memon and execution. If on the other hand the judges decide that they need a stay on the execution, then Yakub has bought himself more time. I think at the moment he's trying to buy time. His lawyers are desperately trying to buy some more time.
What I'd like to understand from you, Kapil, is that procedural lapses and the case that is being heard today, what is the precedence that we have, and is this bench bound by it?
You see, what is being argued today is the letter of law and the spirit of law. Way back in 2002, there was a judgment called Hora versus Hora, in which the concept of curative petition was structured by the Honorable Supreme Court, and the Honorable Supreme Court was of the view that even after the review petition is dismissed, the Honorable Supreme Court can still get into the facts of the legal aspect of the matter and hear the curative petition. And the curative petition would be decided by the three senior most judges of the Honorable Supreme Court, and one of the judges who decided on the main issue or the main petition. So the Honorable Supreme Court, having decided that, the court would take that into consideration. Now the Honorable Supreme Court, in all fairness, is not really bound by its own judgments. It is only a guiding light that the judgments are used as, the precedents are used as. But having decided on a particular structure, decided on a particular method to be followed, I think the Honorable Court is going to check, is going to test whether the curative petition in this particular case did meet the precedent as laid down by the Honorable Court way back in 2002.
Okay, and I want to come back to you for the death warrant that was issued before he could exhaust his legal options, but let's go across to Amrita Shedge now, who's standing by outside the Nagpur Central Jail. Amrita, you were telling us that preparations are on, security has been beefed up in the area even before the court has really decided on this matter.
Definitely, security has been beefed up outside the Nagpur court, but what information now we are getting exclusively for India Today that says that the last mercy petition written by Yakub Memon has been sent to the president this morning. This is the information we have got exclusively from our top sources. This is the last mercy petition given by Yakub Memon to the president, and this is a very clever trick played by the lawyer of Yakub Memon, because the Supreme Court has still not given any decision. The procedure is going on in Supreme Court, and if the procedure not completes till the evening, then in that case Yakub Memon will not have much time to give mercy petition to the president, and because of that Yakub Memon's lawyer has now sent the petition, mercy petition to the president this morning. This is the information that we are getting from our top sources.
Okay, let me come back to Kapil for a view on the procedural lapse as far as the death warrant issue was concerned. That was issued by the Tara court even before the curative petition was heard. Is there a precedence to that as well?
Absolutely. This argument has now been made out by the defense on basis of a latest judgment of the Honorable Supreme Court, which was, I think, in May 2015. This judgment is called Shabnam and Salim judgment, in which the case was that Shabnam and Salim had murdered 7 members of their family. The question was raised that the death warrant was signed before they had exhausted all the legal remedies, and the death warrant was set aside by Honorable Justice Sikri and Honorable Justice UU Lalit. So therefore, this argument has been created in terms of this precedent that before the entire process could be exhausted to safeguard his life and liberty, the death warrant had already been signed.
Okay.
And there are question marks over the way the Maharashtra government therefore acted in the case. I mean, did they show undue haste in putting up this? You know, they could have allowed this entire process to reach its logical conclusion and then set the date. There seemed to be some kind of a hurry, some kind of a haste, fixing up July 30th, and Yakub's lawyers have caught up on that and they've gone before the court. Now, that plus the fact that the review petition and the curative petition should have been heard by the same bench, at least according to what one of the judges yesterday has suggested, clearly suggests that there are certain infirmities that have arisen. Now, are those infirmities enough for the curative petition to be set aside completely is the question. That's what the three-judge bench has to decide. And that, I think, is really now the critical factor in this Yakub Memon case. It's not about the substantive issues which can be deliberated again at a later stage should the court so decide. Unlikely, but procedurally, whether certain things have gone wrong is the critical question.
Is this undue haste that the Maharashtra government has shown has also been one of the reasons why this whole issue has become so political now?
Well, you know, it was always a political case, you know, but I think the manner in which, I think Yakub Memon's case in a sense has always had a political edge to it. Because there has always been a belief among a section of society and a section of the political class that Yakub Memon had actually been brought back as part of some kind of a deal with the intelligence authorities. And if he was to be given life, he spent 21 years already in jail.
Yes.
If he is not to be given the death penalty, will it send out a signal perhaps to others who are in similar situations if they want to return, that the Indian government will then in some ways be willing to ensure that they do not get the maximum punishment? That's the question that was raised. Now, unfortunately, some groups have made it Hindu versus Muslim. And that's the tragedy of this whole case. It's not about Hindu versus Muslim. It's about the law of the land. If the law of the land, and we have a great constitution, allows people to exhaust all their legal possibilities, we must allow them to do that. Someone has pointed out to me, this can be corrected, but a lawyer today pointed out to me that there is a case of Dara Singh in the Graham Staines case, where the court eventually decided in the review petition and in the context of the review petition that this did not fall within the rarest of rare cases, and Dara Singh's death penalty was commuted to life imprisonment. Did that become a Hindu issue? The question is, we must avoid bringing the religious factor into it.
True.
If the same rules applied for the Dara Singh case, they can also apply for Yakub Memon's case. Go by the facts. If it is turning out, Basir Rahman, a former journalist, has written an excellent piece about how material was provided by Yakub Memon, which eventually led the intelligence authorities to identify where Tiger Memon and where Dawood Ibrahim were kept in Karachi. Now, is that not material evidence which will be placed before the court? These are all facts. Now, by making it Hindu versus Muslim, as both leaders from different parties have tended to do, that's why this issue has got complicated and tangled and politicized, rather than allowing it to remain purely on the basis of the law of the land, which Yakub Memon, like every other Indian citizen, has every right to exhaust all his legal options.
Absolutely. Kapil, one more point which Rajdeep was making about the issue of the possible deal that was made between Yakub Memon and the intelligence agencies. Now, one side says that fact has been hidden from the court. Will the court perhaps take a look at that aspect also, or that doesn't come into play at all today?
I believe that the court should look into it, because our reputation as a country is our currency in the international market. And therefore, if in fact there was a deal and it was hidden, it would shock me that the prosecutor failed to bring this before the trial court. Because the prosecutor is not a lawyer for the prosecution. He's an officer of the court. His duty is to bring forth all the facts necessary for fair adjudication of the matter. And if the prosecutor or the prosecution, the police, has not brought proof before this fact, it would shock our conscience as defense lawyers, and more importantly as a nation. Now, having said that, the second aspect is whether these facts were brought before by the defense and what was the decision of the trial court on those issues. Because if there was in fact a deal that was brokered or cut, and in terms of that deal the accused came back to India and brought forth certain evidences, then certain credit should be given to him, and we should honor that deal.
Rajdeep, if I'm not getting it wrong, in the case of Bhullar, the whole issue of his health not doing too well has been placed as an argument. So many people are also using that as an argument here, saying that if he's been in jail for 21 years and if his mental condition is not stable, his family says he's schizophrenic, he's been on medication since 1996, then shouldn't the same argument be applied here?
Look, there are various precedents that you can set. There is the precedent, of course, which is also there, which we've seen with the Rajiv Gandhi assassins, and in the case of Rajwana, where we've seen that there have been political parties which have put pressure. Even after a mercy petition is rejected, the hanging itself has not been executed, and has been delayed. There are examples, as I gave you, of the Graham stain, the case of Dara Singh, when it was ruled subsequently that it did not qualify within the rarest of rare cases, therefore the death penalty was commuted. There are cases, as you have been saying also, of where the mental condition of the person who is on death row is also looked at before deciding whether you should go ahead with the death penalty. And there are, as I said, the law of the land is rich with precedent. And that is what the three judges will eventually follow. That's what the Supreme Court will follow. The problem is the surround sound which has been created by the political class, whether in Mumbai or whether in Delhi, is making it a Hindu-Muslim issue. And that is an extremely tragic element of this entire debate, because the moment you do that, you are ending up polarizing society. I don't think this is about Hindu-Muslim. This is about the law of the land. If Yakub Memon should get a mercy, or whether Yakub Memon's death penalty should be commuted to life, it should be decided on the basis of precedent that already exists in this country.
Okay. Kapil, also, can we take a guess as to how long the three-judge bench will take today to decide on the matter?
As I've already said, this is anybody's guess. But to add on to what was being said, this is a case pertaining to a terrorist attack where a criminal or a terrorist was caught. The question today before the three bench would be what was the question put forth by the two bench as to the curative petition, the constitution of a curative petition and the law thereof. So therefore, as far as I understand, the three bench should in all probability limit itself to the legal aspect of the issues as was questioned by the two bench. Because this three bench has been specially constituted by the Honorable Chief Justice after the two judges of the Honorable Supreme Court could not come to a conclusion on the legal matrix of the case.
Right, they had sharp differences there.
Absolutely.
In fact, at one point, somebody even asking the advocates, do you know who you are, defending in this case? I believe that is what was said by one of the judges to
just goes to show that judges are humans too.
Yes.